Hey there, welcome to yet another episode in this journey of demystifying the Patent Act, where we understand and interpret the Patent Act in simple terms for finding solutions to situations that we may encounter with respect to an idea, invention, or patent in general. A quick recap of what we have been discussing so far. We had an idea, and we are of the opinion that the idea is an invention because it's a new process or it's a new product having technical advancement over the existing prior art or having economic significance. And we are also of the opinion that it finds industrial applicability. As per Section 21J, invention, Section 21JA, which talks about inventive step, and Section 21AC talks about the industrial applicability. We are of the opinion that it is worthy of an invention. We also filtered our idea or invention through the lenses of Section 3 and Section 4, Section 3A to P and Section 4. And we are of the opinion that our idea is not contained in any of the negative list as provided by Section 3 as such or Section 4. At this stage, we are of the opinion that the invention is patent worthy and a patent application should be filed for. But who should be filing the application? You yourself, or your employer, or your professor, or the university where you study in? Who has the right to apply for a patent? Is there a guideline which has been provided which can help us to understand who is the right person to apply for a patent? Section 6 of the Patent Act helps us to understand the situation in a better manner. As per Section 6, a true and first inventor, a person claiming to be the true and first inventor can apply for a patent. Similarly, because an invention can be assigned to somebody, an assignee of the true and first inventor has the right to apply for the patent. On the similar lines, a legal representative of the true and first inventor can also apply for a patent. Now think of it. We have used the term true and first inventor so many times in this slide already. So who is true and first inventor? Do we have a definition of true and first inventor? Section 2 defines, in fact, Section 2 states who cannot be termed as a true and first inventor. Can you recall what is that? What is that section or subsection of 2? Can't? Why? It's Section 2Y that helps us to understand 2(1)(y). That tells us that who cannot be termed as the true and first inventor. So who cannot be termed as the true and first inventor? Any person who was the first to import the invention, basically the product or the process, to India, cannot be considered as the true and first inventor. Similarly, anybody who was communicated about the invention for the first time, or who was first one to understand or who was first one to told about the invention from outside India, cannot be considered as the true and first inventor. So who is true and first inventor? We don't know, but we know that these two categories are not true and first inventor. In general, any person who has contributed to the claims of an invention is considered as the true and first inventor. Not the true and first inventor, but the inventor. And there can be multiple of these guys. So we have identified a true and first inventor for the invention. So we know this person needs to file the application, or the assignee of the person, or the legal representative of the person needs to file the application. A quick recap. Assignee is described by Section 2(1)(ab), and legal representative is defined by Section 2(1)(k). Legal representative is a person who represents the state of a deceased person. Anyway, so we know the category of people who can file for an application. So where should they be filing in? Which office should they be filing in India? Indian Patent Office, isn't it? But we have multiple offices in India, as you may be knowing. So we have an office in Kolkata, We have an office in Delhi, Mumbai, and Chennai. So which of these office one need to select? Which of this office should be selected? All of them or none of them? So as per section, an appropriate office has to be selected by the applicant to file the application. Now, how do we identify what is the appropriate office? An appropriate office is decided based on the place where the true and first inventor, or the definition that we discussed, or the applicant resides or has domicile or has a place of business. So based on the address basically, right? These domicile or place of business. Based on the addresses, we defined a location. And that location needs to be under the purview of one of these patent offices. All these patent offices have territorial jurisdictions across India. For example, people belonging to Rajasthan will go to Delhi. People belonging to Karnataka will go to Chennai. Similarly for Mumbai and Kolkata, people of Bihar will go to Kolkata. Based on the location, we decide what is the appropriate office for an application to be filed. If we don't have such addresses, then what we can do is we can identify a location or place where the invention was originated. That place, the information about that place also could be used to select an appropriate office. Now, an interesting question at this stage should be, in India, foreign applicants can also file patents. So what would be their appropriate office? Because they may not have the residence in India or place of business in India. So in such cases, they need to have an address of service in India. They need to provide an address of service in India where the patent office will communicate with. Now, usually this is based on the patent address of the patent agent that has been appointed by the foreign applicant or the applicant. Interesting fact about it is, if an address of service is not provided, then patent office has no obligation to take the invention forward or process the patent application. So the address of service is an important and mandatory requirement. With this, we understood that a patent has to be filed, a patent application has to be filed in an appropriate office for patent office to process it. Does it mean that only that particular office which has received our patent will be processing the application? The answer is no. It's an interesting fact. Whichever office you file in, based on your appropriate office basically, the patent offices can transfer the file across the offices for it to be processed. So if you have filed an application with Delhi Patent Office, you should not be surprised if you receive communication from Kolkata Patent Office or Mumbai Patent Office. It is distributed these days. So this brings us to the end of this session, where we have our answer that the inventor or the true and first inventor or its assignees or the legal representative have the right to file the application in the appropriate office. The next obvious question is, how do we file the application? What are the forms and what are the requirements and what are the documents that needs to be prepared to file an application? Tune in to the next episode where we will discuss the basic requirements of initiating such a filing. Till then, take care and read well. Bye-bye.